And that really should start from that very first meeting, or second or third, somewhere in the beginning. And I always like to say that Johnny Cochran back in the OJ trial stole my theme, because I had his theme before, and I swear he must have been in my courtroom. I was a new lawyer as a prosecutor, and I had, from trial advocacy, we had learned to come up with a theme, especially with juries. Juries need to have a theme. So, you know, in family law, the judge is your jury. And so I stuck with a theme in every case. And so my theme, it was a stealing case. This guy stole pants from Venture. If you're old enough to remember it, we used to have Venture stores here in St. Louis. And right next to the Shop and Steal, which was a shop and save. And so I was trying it, and his defense, believe it or not, was it couldn't have been me because the pants that were stolen don't fit me. And so, you know where this is going. I'm telling you, my theme was, if the pants don't fit, you cannot acquit. And so the OJ was, you know, if the glove doesn't fit, you must acquit. I swear to you, that was my theme. It was before OJ. And it worked. And literally, the jury was out for 45 minutes. And the thing is, you can have a theme in anything. The ones that always come to mind, and that theme has to be wrapped into your questioning. It can't just be in an opening, which we don't necessarily do in St. Louis County, but we should be doing closings. I really am a big fan if you can do it, do some sort of closing argument. But that theme has to resonate through every question. I had a case where the wife assaulted the husband significantly and broke both orbital sockets in his face. And so, anger, assault. So those two words I tried to put into literally every question, every area, every issue. So when you take your children to school and you go to parent-teacher conferences, do you have that kind of anger that you display to your husband when you're there? And when you're with your children, do you talk about the assault of your husband? I mean, those words, every word. I want the judge to hear anger, assault, to the point where that's all they remember. You have 40 minutes, 50 minutes before the judge will lose maybe some patience and attention. So you want to get your point across. That's effective cross, effective direct, whatever it may be. And it should be a single word or a few words. That's because you can't, that theme gets lost if it's not. It just needs to be something. That's why I said, if the pants don't fit, you must not acquit. I mean, a little bit lengthy, but the jury got it. So when you're developing it, you need to do that. And especially in your outline, one of the things, I kind of gave you an example, and this is where I got from the Posner book. So, I mean, I threw this together and quickly, and I stole some of the references from a case I had. This outline is really an outline, and it's an outline of ideas. And so what I learned early on was you need to have one-page outlines. And you have an issue. For example, this one was maintenance. And see, I've got my theme, home by choice. My theme should always be at the top, so I always remember, home by choice, home by choice. It was a maintenance case where the spouse, she decided that she was fully capable, children were grown, she just was staying at home by choice. So every question was, so do you stay home in your home by choice? Yes. And so how long have you been home by choice? And that I wanted to just drill in. And it annoyed the witness, which is good because I wanted her to get angry and kind of be a little flustered. But, so maintenance has a lot of issues. Maintenance has issues about income. Maintenance has issues about expenses. Maintenance has issues, could be about support from someone else, a third party, a roommate, a lover, whatever it may be. So every page is a sub-issue of your main issue. And I try to keep no more than one page. Posner will talk about that because I think you can get your point across, and I'll do a sample in one page. And I think if you can do that successfully, the judge will hear your cross and be much better at getting what you're trying to get across much faster. So these are things so I always draw a line down the middle because I want to separate my issues by my proof. And so you'll have if I'm talking about a bachelor's degree, well, there was some question about whether or not she had a degree, and she was claiming she didn't. And so I'm cross-referencing the depot page and the line number quickly. So, I mean, before I did this, I remember thinking, I know that she talked about the depot, and judge, just give me a minute, I need to find this in the depot. I mean, how annoying is that for the judge to be sitting on the bench while you peruse 400 pages of a deposition trying to be able to impeach the witness. So your outline should have the references, and it can have, I'll talk about bait stamping, I know Kelly mentioned it, but it should reference exhibits as well. I usually draw another line as I'm in trial on the far right, and I'll reference the exhibits that I'm going to use on those specific topics. But you want to go through that, and this should be in your exhibit book, not the one obviously you give to opposing counsel, but I'll do this page on top of every exhibit that I have, like the stack, that reference, maintenance. And I try to keep them chronological in order, so I'm not jumping, moving to admit exhibit number 37 when I just did number 1, and I haven't done 2 through 36. And that I know is annoying to judges. Now, where are you? Are you on 35? Are you 2? You're not in order. It is frustrating. So organization is key when it comes to cross-examination, not only from effectiveness, but from flow. So this you'll see, and I'll reference it again a little bit later, that it's important to make sure that you have an effective outline. I know Kelly talked about the depth of your knowledge, and this is somewhat a repeat, but you have to know your case inside and out. And I know there's some attorneys that I have had cases against, and I used to admire, and I know that probably in here, they wouldn't have an outline. And I was younger, and they would walk in with their exhibit book, the binder, the 3-ring binder with their exhibits, and their direct and cross was guided by their exhibits. They knew the file, they knew the facts, they knew the case, they didn't need an outline, they just needed the exhibits. And they literally had the exhibit book in front of them, and they would just walk through, and they would just start going down that road. The witness may take them in a different direction, and they would continue, but then they go right back to their book. And organization and knowing your case is so important. It's impressive to the judge. I mean, that's one of the things that we try to impress upon the younger attorneys is over-preparation. I'll sit at home at night, and when I was doing a lot of the trials, I was up till 2 or 3 just because I wanted to know my case. And it was on my time, not on the client's time, because I took it personally, and I wanted my presentation to be that. I wanted it to be organized. Don't be vague. You'll lose the judge if you're vague, and you'll lose the witness. And then you're getting into this banter back and forth between you and the witness, trying to figure out, they're playing with you now, rather than you taking advantage of it and directing the case. I mean, you have to control the case. You have to control the witness. And then Posner, and that book gets into how you do that, and that's what's important. As you prepare, also know your exhibits thoroughly. And then also the opposing counsel's exhibits. You want to use those. We'll get the book right away, and there may be exhibits I'm going to use. I'm going to introduce them. I want to get them out of the way. Nothing like, I'm a big fan of filing first, just from the standpoint if I get to present my evidence first. And then I can use some of their damaging exhibits first, and try to get that out of the way and soften the blow, rather than waiting until they get on and they hurt your case. Bait stamping, I know Kelly talked about bait stamping everything. That is hugely important. From the very beginning, Posner, I think it's Posner has or it's Bicken's book. She talks about something called a trial ledger. In one of my cases, I don't really create a trial ledger, but it's the very beginning of the case, and it's every document that comes in the door gets stamped. From the very beginning of the case, from correspondence to discovery. I remember the mistakes you make when you're a younger lawyer is asking the judge, well, it's on page 4 of Exhibit 3, and it's about 3/4 of the way down, and they don't know now, well, I don't know where you are, and I have to go up to the bench and show them. And it's just, if it's bait stamp, it's bait stamp 675, judge. Okay, there it is. It's there's some copiers that actually bait stamp now for you if you want, but keep it in sequential order from the very beginning of your case. It makes it easier, especially when you're putting your exhibit book together, and then your exhibits. On my exhibit list, I always reference what exhibit bait stamp numbers they are, so it's very clear, nothing gets lost, nothing gets out of order. If you drop the exhibit packet, whatever it may be, bait stamp is huge. But it's everything. Discovery, especially when I'm getting discovery in, I'll bait stamp it so I know I can reference it, and I'll start a different section of bait stamping numbers, maybe 0 to 1,000 are mine, 1,000 to 3 are theirs. That way I know where they came from. You can intimidate a witness through control. And through that control of the testimony, the witness can then begins to think you know something that you don't really know. And they get nervous. And their testimony becomes much weaker when you control your case. There are 12 commandments of cross-examination that I try to live by. They are, don't ask a question if you don't know the answer. We all know that. Always ask leading questions. The spotlight shifts from the witness to the lawyer, as the lawyer will now be telling the story. You don't want the witness to tell the story. You tell the story. I mean, I know there are lawyers that took classes in storytelling, especially with juries, and that was a big thing when I was doing jury trials early on, was you're telling a story. That's all you're doing. In your questioning, move from general to specific, nothing vague. Be clear and brief. Never repeat a question that hurt you on direct. Do not argue with the witness, and that is one of the hardest things to do. When you know a witness is lying, or you get that aha moment, you want to start arguing with them to get your point across, but you don't need to. Know the theory of your case and how the questions you are asking of your witness add to your theory of the case. So if they twist it, loop back. There's always questions, things here. The next one is loop each question from the answer given in the preceding answer. So you can take that answer, reference it by looping into the next question. Your questions have to make sense to the judge. They make sense to you because you know the case when you're thinking about it, but do they make sense to the judge? And that's what matters. Never ask a summary question that might give the witness an opportunity to retract testimony or explain away responses. Be brief with your questioning. Begin and end cross on a high note. So when your first question should be a big one, because everybody's waiting to hear it, and your last question should be a big one, and end on it. Don't be drawn into that notion that you have to ask one more question. If you made your point, don't ask another one to make your point again. You just need to stop. But go in the direction that the witness takes you. If you're on your outline, we were talking about that outline that I have. Let me back up. If you're on education and the witness starts talking about general experience, don't leave general experience, finish it. Loop back to education when you're done. Just let it flow, go with what the witness gives you, but make sure you circle back and finish what you want to do.
Okay.
All right, financial documents, one of my favorite things to cover. I think is the most effective cross-examination tool, and I'm going to go quickly, I know we only have half an hour. You can effectively destroy a witness utilizing financials. Financial statements, income and expense, and statement of property. Both in tax returns, W-2s, these are the things you're going to want to use. Bank statements, credit card statements, business documents, profit and loss, all the schedules from your tax return, perhaps invoices, QuickBooks, and I would add one where you create an Excel spreadsheet that goes through bank accounts. I'll typically have my legal assistant go through their bank account and their bank statements and Excel spreadsheet all the deposits and all the withdrawals and see and match that to their pay stubs. Because it'll be interesting to see that where's that extra income coming from. And that's the best way to find it. You can have that as a summary sheet on top of your exhibit. You'll get an objection, but it's at least already in the book. Judge is probably looking at it. That's the beauty of judge-tried cases. It may not be admissible, but the judge is looking at it. And to think that they're going to strike that out of their mind, I think we're all fooling ourselves. But I want to reinforce that when you're doing cross, especially when it comes to support issues, you want to make sure that it's, again, one page. If you have to go over gray, that's fine, but I just think that you can, and I'm going to give you a sample cross here that I think would be contained in one page. Support, you're always questioning income and all sources, everything. But none of this should be new to you at trial. It should be all addressed in your discovery, in your deposition. Bonuses, deferred income, investments, investment income, not just investments. Investment income is huge. That can be used to show additional income, depending upon where that investment income is going, even if it's reinvested income. Fringe benefits, rental, leased cars, leased vehicles, self-employment. Don't take the tax return for face value. You know, we'll utilize, we have LLMs in our firm, in our house, that will look at that and give us an income analysis. But utilize the services of an accountant. If it's a complex matter, please don't shy away from that. And they're the wonderful testimony. Get away from the he said, she said. Get away from arguing with your opposing party on a cross about their income, because they probably won't give. Or they'll say, well, I don't know, my accountant did it. Question their expenses. Tear apart the financial statement. I'll blow up the income and expense statement on big boards. Place it right next to the witness, and that's where we begin. This is how effective it is. So I'd opened our Atlanta office, and we had a trials and maintenance issue. We filed first, and which I like to do, and it was a week long. I was on day 3, and I had the spouse on there for a full day. And we were just simply talking about her financial statement. The key was to create confusion. If she started eliciting testimony on cross that she really didn't understand where the expenses or those numbers came from, then there was some law that talked about the judge couldn't make a finding based on her testimony as to what the expenses were, that they were just, no one could present any credible evidence. So I had crossed her about, we used affidavits on electricity, water. We really went through and crossed significantly. And so how effective it is, I said, Judge, I rest my case. And so the respondents getting ready to do their case, and this judge was a semi-retired judge on the bench, good old Southern boy judge up there, and he kicks his feet up, boots on the bench, and starts reading a newspaper as the opposing counsel starts his case. And he was getting nervous, walking back and forth, talking louder, just trying to get the judge's attention as he's kind of trying to rehabilitate his own client. And he says, Judge, I just want to make sure you can hear my client. I know she's soft-spoken, you know, and trying to, of course, inject some other themes of his case. And the judge peered over his newspaper, just his eyes. He says, Alan, I've already heard enough. It's all good. And so the point was, he'd already heard enough. We had destroyed her on the financials. He didn't want to hear any more. He had gone through 3 days of our case and didn't want to do anything. I mean, that happens a lot. When I was younger, there was a singles county judge. I had gone second. It was a contempt case. I see the judge working on a computer, and I'm thinking, what is he doing? And I get up to do my case, and I kind of weave around by the clerk, and he's preparing the contempt order. I hadn't even started my case. You can effectively make that decision through your cross-examination, especially when it comes to support issues. You want to question the income, career opportunities, as I referenced. Let me give you a quick example of how fast I think an examination can go and you can prove your point. So you're the attorney. This is your tax return. Yes. You were involved in its preparation? Yes. You provided the information to the accountant who prepared it? Yes. The information was accurate when you provided it? Yes. You signed the return? Yes. This is the return you filed with the government? Yes. This is the Schedule L, otherwise known as your balance sheet? Yes. It shows a balance of loans to officers of $145,000? Yes. You're the only officer of the corporation? Yes. At the beginning of the calendar year, the loans to officers balance was $25,000? Yes. Now at the end of the year, the balance was $145,000? Yes. The schedule shows retained earnings of $220,000? Yes. The retained earnings at the end of the year were $270,000? Yes. You could sit down. What you just, I think if you were, it went fast, but you can show through that simple 15 or so questions that we have a client who's probably underpaying themselves, taking loans from a corporation in lieu of income of $145,000, and leaving retained earnings in a company up to $270,000. The questions you asked were all yes questions or no questions. They were all leading. They were all specific, nothing vague. You got your point across, one-page outline. In a support case, that could be it. You don't have to hammer it through every page of the tax return. You determine the salary right there for the court. The expense part, there it is. So on the expenses, you want to question and go through detailed cross on those expenses. That's where you probably, sometimes with my one sheet, I may spill over because I can go 4, 5, 6 hours on just income and expense statements. And especially when you have alternate sources of income. Social Security, disability, you may have older children, especially when it comes to how long is it really necessary when you have child support, when you have a child in college where neither mom or dad are supporting the child, it's all loans. The child has a work-study program, or the child's employed outside of school. You're going to get very specific, and it may take a little bit longer for you to go through those issues. Quickly, I'm going to go through custody. The best thing I do, I'll usually attach the statute, the relevant statute for income, for maintenance, or for spousal support, child support, and custody. I mean, we all know it, but I usually have it there. I'll make sure that I have it referenced, and I'm going to go through all the points. I mean, one of the things I never want to happen on appeal is, well, they didn't cover any of the relevant statutory points. I'm going through every point on my question. And it should be wrapped into your outline. I mean, we know it, we can probably do it by heart, but I have it there. I want to review it, make sure I've covered it, go through and propose parenting plans. I try to start emotional, touchy-feely on custody issues, using pictures of the parent with their child, doing something fun, and then get into proposals. One of the very things I want to do first in a custody matter is what's the judge want to know? What do you want? So give them a parenting plan right off the bat. So before we get into your custody, before we talk about your kids, is this the parenting plan you're proposing? Yes. Have you reviewed it? Yes. I mean, you want to get specific, but the danger you want to be, and the caution is, make sure that whatever you propose, your client's very comfortable with if the roles were reversed. It's just a slam dunk cross-exam question. So if this were you, would you be happy with this? Sometimes they're not prepared for that, even if it's not, and they have to be able to explain it away. Skip through a little bit. Oops, go back. Frequent meeting and contact. One of the things I like to do when we go through some of the custody issues is make sure that I can bring in third-party witnesses, things that talk about the relationship between the parents, what's going on, bring in teachers, doctors, they get away from the he said, she said. You want to make sure that you're not focusing just on what your client says and trying to prove his credibility over the others. Bring in third-party testimony to support what you're saying. It's probably one of the most helpful things when it comes to cross-examination and proving your case. Danger on cross-exam on mental health, especially when it relates to support issues. If you want to go down that road and prove perhaps some mental unfitness, be ready for a support argument that you're making against yourself, especially if you're the obligor. You're going to basically set up a maintenance case. So I always talk about if you're going to raise unfitness, mental health issues, make sure you can win. Because to make sure you understand that as a result of that, that you're likely going to be facing some support issues on the other side. That goes into the good parent. Be careful about proof. Don't get into objective or proof that are really conjecture. I have a lot of clients that says, well, drug test her. Well, what if we drug test you? And is she going to come out positive? Are you sure? Because if she's coming out negative, it's going to hit you on cross-examination. All right, sorry I went fast, but we only have 15 minutes. I want to leave as much time as I can for Kelly to continue on the use of experts.
Okay, so we're going to run through some of the slides. I think you all have the presentations. I'm going to run through a few things pretty quickly. But, we're going to talk a little bit about experts because that's such an important part of family law cases. And in most cases that you take to trial, you're going to have some form or fashion of expert. These are obviously the most common experts that you see in family law cases. The good news about sort of having the same people in most cases is that you kind of with experience have an idea where a cross is going to go generally with most cases. The bad part of that is complacency. making sure that you don't sort of rely on the same thing you've done in all these other cases with the cross in this particular case. And keep in mind that each expert is different, each case is different, and they need to be tailored as such. You know, a couple of things to keep, some things to keep in mind as you're preparing a cross for an expert and you're preparing for trial. Make sure that you get a scheduling order, or you have enough time that you're getting that report from the other side's experts with plenty of time to do something about it. Don't forget about rebuttal experts. A rebuttal expert is also going to play a very important part in your cross, because again, we're going to talk about that minutia. That's sort of my theme, I think. The minutia, you don't want to weigh down your cross with minutia that can be better explained with a rebuttal expert. So you're going to hit your points on your cross with your expert, and then go into the details of the differences in the reports and things like that with your rebuttal expert. So always get a rebuttal expert if you're getting a bad report. I understand we'll talk about the hired gun versus the court appointed a little bit later on, so I understand that at times that rebuttal may be a hired gun where you have a court appointed expert, but I've seen cases win with the hired gun rebuttal expert because they made really good points, and you made really good points on cross. Know the report and the expert's deposition cold. Know it better than the expert does. Because I can tell you this is probably not the expert's only case, and they may not have, it may have been months from the time that they did the report to the time that they're doing the cross-examination, and not everybody prepares. So they may not know a lot of the information that's in their report or the documents and things that they use to prepare the report. So you knowing it better than they do is going to help you significantly on cross. You know, I'm not going to spend too much time on the Daubert challenge and voir dire, just to say that, don't forget that those are options to help you discredit the expert's credibility. Those are things that I hardly ever see used, and that also, again, keeps you from spending a lot of time on cross. It's a great way to discredit your expert with the judge, even if you don't think, likely the expert's not going to be thrown out, but those challenges are very helpful because you spend basically an hour to 2 hours hammering on why this expert is so bad and is not going to be very good. So those are great tools to use to, again, thin down your cross-examination and get that information out ahead of time. Use your time on cross to highlight the major errors, hit the big points. Like, again, go into details with your rebuttal expert. You also, when the opposing, when you're going through your ideas, use your cross and tailor your cross and outline your cross by using the opposing party's expert against their ideas and their concepts and their reports against them. Attacking the expert's qualifications is going to be an important part of the beginning of your cross, and again, if you can get that done through a Daubert challenge or voir dire, great. If you can't, make sure that you go into those credentials, and we're going to talk a little bit later, I've got another slide, about using the standards of practice for that expert against the expert, and making sure you know those as well. Attack the expert's methodology. Attack underlying assumptions. Bias and prejudice is a huge part of what most experts bring to the table, especially when you're talking soft sciences or social sciences. Those experts bring a lot of their personal feelings and biases into their reports. I'm going to go through these very quickly, but these are some points to consider that you already sort of have in your outline and things that you can read over. Listening for the basics when you're listening for the direct and you're listening on cross, the responses that you're getting on cross, make sure that the expert knows the legal elements, that they know the standard of proof, that they're adhering to that standard of proof. In your deposition, when you're deposing these experts, these are all things to be thinking of in preparation to depose the expert. And when you're deposing the expert, making sure you're hitting these points. So potentially you can be making these points on cross-examination. Also listen when they're directing. Have they asked these questions? Do they know, does the expert know the law on this? And are they adhering to the standard of proof? The standards that you have to go into as an expert and the standards in their profession, make sure that you're going, most of this stuff is on websites, so all you really have to do is Google standards in this particular practice for social, for custody evaluation or social study, models for standards of practice. The Association of Family and Conciliation Courts has all of these things. So these are really good fodder for cross-examination. Go through, find out what the elements, find out what things that they are supposed to be complying with, and use those against your expert, the opposing side's expert. Don't be satisfied with just going into their experience level. Yes, it may seem impressive that somebody has 20 years experience as a whatever. However, they may not do the same kind of thing. They may have very little experience with what they are testifying in their report in this particular case. So for example, you have somebody who's been a therapist for 20 years, but maybe they've only done 2 or 3 social studies or custody evaluations. So don't just be satisfied with, hey, this person's been doing this a long time. Maybe they haven't been doing this particular thing for a long time. Do they have specialized knowledge and training in the area? Do they just do general things? For example, a lot of clients or a lot of parties will want to use their personal accountant as their forensic accountant in a case, and I've seen a lot of attorneys allow that to happen to save money. Bad idea. And that somebody may have been an accountant for 30 years, but they don't know anything about tracing, they don't know anything about business valuations, and those are things that you can really hit on. Know before you ask about their testimony in other cases. So I kind of have this example. I was a very young attorney and made a bad mistake in this one case in my cross because I thought I was going to score all these great points. And I was maybe out like a year or so, and I had this trial, and there was a custody evaluation that the expert had done. She was evaluator for the state. And so I get her up there, and I'm scoring some great points, and I ask her, thinking that, I'm representing Dad, figuring that most of the time she probably finds her mom in these cases. So and I ask her, isn't it true that most of your cases you find for the mom, or you find that custody should go to the mom? Well, no, actually, I've done about 6 cases this year, and 4 of them I found for the dad. So I didn't really score points on that. So know what those kinds of responses are going to be before you ask those questions. And I think it's sort of one of the tenets of cross-examination is, you have to know the answer before you ask the question. So, that was a huge learning experience for me, even thinking that I would know what she was going to respond, and the response was not quite what I thought it was going to be. Obviously, bias is an important thing to use for your cross-examination. Most people are going to have bias. Look at past opinions in similar cases. I think, probably one of the areas, especially in soft science experts, is their previous bias, or whether they're willing to consider thinking outside the box with respect to these kids. Are they sort of boilerplating or rubber stamping the same solution on every case, or are they really tailoring their opinion to the particular family in a particular circumstance? So for example, if you have an expert that would never consider a 50-50 possession and access schedule, do they ever do that in any of their cases? Or maybe they always do a 50-50 access and possession schedule. I had one expert in a custody evaluation that just felt that it was his personal bias that, very young children needed to be with the mother in pretty much every circumstance. So that was a really good point, and something I really, again, my theme in my cross-examination for that witness was that particular point. Dual role experts, and this can happen really with therapeutic and soft science experts as well as financial experts. As I mentioned, the accountant, the family accountant that is now being tasked to do tracing. Their roles are very different. So what is a dual role expert? It's somebody who is usually used in one capacity that's now being used in another capacity. So for example, a therapist. The therapist for the kids is now being asked to make a forensic decision about what's in their best interest. Bad idea. Why it's tempting, why a lot of attorneys use it, because it's cheap. It's one witness for everything, one expert for everything. They don't have to go out and find somebody else, and this person has a lot of experience and history with this family, so they know the case. They know the kids, they know the case. It's bad and right for cross because it really, for many reasons. For a therapist, it really ruins the therapeutic relationship with the kids. So if you have children that are seeing a therapist. Those roles are very, very different. And if the kids are trusting this person to, they've established this role and this trust, that's going to completely disintegrate upon that person being called to testify as a witness to what the children said. Also, the tasks and goals for a therapist and a forensic expert are very different. The forensic expert is very neutral and looking at this in a way that they can testify to the judge as to what's in the best interest of the children. The therapist is not there to do that. The therapist is to diagnose any issues that these kids or this family might be having and not to opine on the ultimate issue. So if you have a therapist that's up there trying to opine on the ultimate issue of best interest or possession and access or conservatorship or whatever it is, they just laid the groundwork for your cross-examination. So court-appointed versus hired gun experts. Obviously, a court-appointed expert, the advantage is that they are a neutral, so if they come down on your side, they don't have a stake in the game. So when they come down on your side, that's great and that's wonderful. When they don't, obviously it's problematic. You have to be careful because even in your cross-examination, because a lot of the times these court-appointed experts are favorites of the judge. They potentially may be even friends of the judge. So you have to be a little cautious how bad you're tearing them apart in cross-examination, but at the same time you want to make sure you're scoring points. So, there's never a reason, especially with experts, to be particularly nasty, but you want to be sure that you're scoring your points. Making sure that you're making those decisions, you're making your points and moving on with your expert. Also, the nice thing about the court-appointed is obviously they're going to have access to both sides of the case. They're going to have access to all witnesses, all parties, the kids potentially if it's a therapeutic, both sides of the deal. However, one of the things to make sure that they are doing is are they using that? Are they utilizing both sides of the fence? Are there witnesses that they've talked to on both sides? Another thing with respect to bias is sometimes you'll have court-appointed experts that really like mom and they'll spend hours and hours and hours with mom or dad. And then they really don't spend a lot of time on the other side. Or they'll talk to a lot of the collateral witnesses on one side, but they won't talk to collateral witnesses on the other side. So those things are things that you can really make points and cross. A hired gun, a lot of people are hesitant to get a hired gun in their case or a rebuttal expert in their case because they're afraid that the judge isn't going to put a lot of credibility into it. Some of these people, because you have the opportunity to hire the best person out there instead of somebody that the court just kind of always appoints, you can hire some really, really excellent experts out there that kind of negate the fact that they're a hired gun. They're that good. So be sure that when you're using a rebuttal expert that you're getting somebody very good, and also know the weaknesses of your rebuttal expert. Remember, they're not talking to both sides. So it's really important, I think, when you have a hired gun to make sure that they are when you've hired a hired gun to make sure that they're very good and that they're not testifying to things that they just don't know. So you don't want them opining about what's happening with the other side or based on this report or what my client, your client has told the expert what they might be, opining on the ultimate issue as to what this person's told them about another person. So be careful on those issues. Some other words of wisdom, just going through cross-examination, make sure the judge is following your cross-examination. Scott kind of got into that a little bit about tailoring your cross and making sure you're hitting your points and having that rhythm and don't get too technical in what you're discussing so that the judge loses you. Remember, some of these judges are general jurisdiction judges and you kind of have to teach them the law on some of these issues, especially if you're getting into super complicated areas. So, it's not a mistake necessarily to put your cross-examination in simple language and really making sure when you're talking to your direct witnesses that you're clarifying some of those points and preparing for your cross. If you're slow at your delivery, the judge will be bored, so make sure again that you keep up with that pace and you don't get bogged down in the minutia. If you're wasting time, the judge gets angry. I've seen numerous attorneys that will harp on a point and harp on a point and harp on a point, and I've also seen judges that, and I'm sure you have too, that will say, move along, counsel. Once you make your point, move on. You don't need to beat a dead horse. You don't need to harp on the same issue over and over again. Don't waste your time in your cross-examination making points that are better made in your direct. Use your direct to get all that information out and your cross just to hit your high points. Simple words and sentences, simple words and points. Do not ask a question, again, that you do not know the answer to. I know that this is a basic tenet, but I see it happen all the time, and you just need to be cautious with it. Again, don't beat a dead horse. Gauge the courtroom and how is the judge responding. If you think that, I use this example that I had a case where adultery was the big issue. My client really, really wanted me to make a huge point about this adultery in the cross-examination. So, you know, I start making my point, and you can tell that the judge just really isn't interested. And also from the direct and other things that have happened, that the judge really doesn't care about the adultery issue. So it's important that, you know, I kind of knew that at that point, even though my client kind of wanted me to just really, really harp on that, you know, we prepared, and I mentioned to him that, you know, I'm going to need to move on from this if this is not something the judge is interested. So you want to know your judge and make sure that the points that you're making are scoring with your judge and your judge on the board. Know when to quit. When the witness has been discredited or you've scored your major last point, sit down. Don't ask that last question. Also, when the witness is hurting you more than helping you, maybe it's time to just quit while you're ahead. So I'm going to try to quit while I'm ahead. And thank you for your time today. I appreciate it, and I think Scott has a couple more comments.